recently, I came across this book. I bought this book years ago, and I read it when I first started practicing law, and I found it in my basement amongst all of my books, and I brought it to my office, and I was flipping through it this morning. It's written by Bryan Garner, who used to be, and maybe he still is, the editor for Black's Law Dictionary. And I can remember the first time I read this book. I hadn't practiced law more than a year, but it's even more true now. I remember this statement about writing for, quote, a mythical judge who might someday review the document. He says, today, the prevailing attitude, unfortunately, is that lawyers should draft contracts, legal instruments, and statutes with the judicial reader in mind. But this approach is wrong-headed, and he gives 5 reasons. The first reason, and I'll read it to you in its entirety here, he says, lawyers who draft for judges tend to adopt a highly legalistic style, since judges have legal training. Yet, because these lawyers aren't litigators, they almost never interact with judges. They don't know how much most judges detest legalese. And he gives 4 more reasons. Number 2, the judge won't see it. So just a fraction of 1% of all of the legal documents drafted ever get litigated or brought before the judge. The legalese doesn't prevent litigation, which it doesn't. Number 4, the more legalese and jargon that's in your document, the more it's going to be ignored by the people that you wrote it for. And then lastly, the more jargon that you put in there, the more divergent interpretations will arise. So the more dispute there will be over what the document actually says. So this is excellent. It's absolutely true, particularly the first point. I would say of lawyers who handle transactional matters, so real estate, contract, business lawyers, I would say at least 80% of those lawyers, if not more, never go to court or have never even been to court, and they don't know the first thing about litigating one of these documents. And it shows when you have to deal with these lawyers and they want to fight you to the death over the stupidest little thing in a contract, and they need to reword and rephrase everything. It reads like garbage, and you could just tell they have no clue what actually goes on when one of these documents goes before the court. Just to give you one example, the last trial I had was this extremely convoluted legal mess between 2 parties, and there were over 15 years worth of legal documents. Right? This was just everything preceding the trial was a cash cow for the lawyers involved with these parties, and they just wrote dozens and dozens of legal documents, made a fortune until the whole thing fell apart, and we ended up litigating the matter. Now, the lawyers who drafted all these documents did not litigate this. Right? I did, and another lawyer did. And we got before the court with all these documents and all of this jargon and whatnot, and you could just see that the judge's head was spinning. Right? She couldn't wrap her head around it. Probably 98% of all of the documents meant next to nothing. Certainly the terms and everything else that had been probably hashed out for hours and hours and hours by these lawyers. It just all amounted to nothing. Right? So you should find a lawyer who is going to speak to you in plain language and who is going to prepare your documents, whether it's a business contract, a lease, a will, whatever it is, in words that you can understand. Right? You're not going to gain anything by having some lawyer write something that's 10 times longer than it needs to be, using all kinds of language that you don't understand. And if your lawyer is insisting on it, or if you're at a stalemate with another party over contract negotiations, over some terms, just ask the lawyer point blank, have you ever litigated this? Have you ever gone to court with this sort of a thing? And if he says, yes, I have, then listen to him. And if he says, no, but I heard of this other lawyer and something similar happened, then you should become a little bit suspicious, all right, about how important it is to have the jargon that he wants in the contract in there. So if you have your own thoughts on legal writing, I'd love to hear them. And if you have questions, send me an email.